The most powerful Supreme Court attorneys in America thought they were facing another weak Chief Justice when everything went catastrophically wrong. The stunning brunette they'd been dismissing for her youth and beauty had just delivered a majority opinion so devastating that it would end their careers, change constitutional law forever, and establish her as the most feared legal mind in Supreme Court history. What they didn't know was that the gorgeous young woman they'd been treating like an inexperienced figurehead was actually Chief Justice Isabella Gavel Montgomery, and her perfect legal reasoning was about to destroy not just their arguments, but their entire professional legacies. Welcome to Silent Hero Stories. Before we begin, tell us in the comments where in the world are you watching from today. And if you believe stories like this deserve to be told, hit that subscribe button. Now, let me tell you how we got to this historic moment. The Supreme Court of the United States had always been an institution built on tradition, precedent, and the kind of institutional respect that came from centuries of legal authority. For most of its history, the court had been dominated by older men whose gravitas came not just from their legal brilliance, but from their age, experience, and the weight of decades spent in the highest echelons of American jurisprudence. Which is why the appointment of Isabella Montgomery as Chief Justice had sent shock waves through the legal establishment that had nothing to do with her qualifications and everything to do with her appearance. At 34, she was not only the youngest Chief Justice in American history, but she possessed the kind of ethereal beauty that seemed more suited to magazine covers than Supreme Court chambers. With cascading dark hair that caught the light like silk, piercing green eyes that seemed to see through pretense to the heart of legal arguments, and features so perfectly sculpted that they appeared almost otherworldly, Isabella looked more like a Renaissance painting of justice personified than the kind of stern judicial authority that lawyers expected to find behind the Chief Justice's bench. The legal establishment's reaction to her appointment had been predictably dismissive. Senior partners at the most prestigious Supreme Court practices had privately questioned whether someone so young and beautiful could possibly possess the intellectual gravitas necessary to lead the highest court in the land. They assumed that her appointment was the result of political calculation rather than legal excellence, and they prepared to treat her with the kind of condescending respect they reserved for figureheads who looked impressive but lacked real authority. What none of them had bothered to investigate was Isabella's actual record. Her path to the Chief Justice position hadn't been political favoritism, it had been a meteoric rise through the legal profession based on intellectual brilliance so profound that it had earned her the nickname Iron Gavel among attorneys who had learned to fear her methodical approach to legal reasoning and her absolute refusal to accept anything less than perfect constitutional analysis. Isabella's academic credentials were flawless: Harvard Law School summa cum laude, editor of the Harvard Law Review, Rhodes Scholar at Oxford where she had studied constitutional law under the world's leading experts in legal philosophy. But it was her brief tenure as a federal appellate judge that had established her reputation among attorneys who were paying attention. In 3 years on the appellate court, Isabella had written 37 opinions that were considered masterpieces of legal reasoning. Her decisions were so thoroughly researched, so precisely argued, and so intellectually devastating to opposing counsel that they had become required reading in law schools across the country. She had never been reversed by the Supreme Court, not once, and her legal reasoning was so airtight that even attorneys who disagreed with her conclusions were forced to respect the brilliance of her arguments. But the Supreme Court Bar, the elite group of attorneys who specialized in arguing cases before the highest court in the land, had been too focused on her age and appearance to pay attention to her intellectual record. They saw a beautiful young woman who looked like she belonged in a fashion magazine rather than a judicial chamber, and they prepared to treat her accordingly. The case that would expose their fatal miscalculation was Blackwater Industries v. Environmental Protection Agency, a constitutional challenge that would determine the scope of federal regulatory authority and potentially reshape the balance of power between government and industry for generations to come. Blackwater Industries was a massive conglomerate that had built its fortune on exploiting environmental loopholes and regulatory gaps. When the EPA issued new regulations that would cost the company billions in compliance expenses, Blackwater hired the most prestigious Supreme Court practice in Washington to challenge the regulations as unconstitutional federal overreach. The law firm of Sterling, Whitman and Amp, Associates had built their reputation on Supreme Court victories that had consistently limited federal regulatory power. Senior partner Harrison Sterling was considered the most feared Supreme Court advocate in the country, a man whose courtroom presence was so commanding and whose legal arguments were so sophisticated that he had personally argued 43 cases before the Supreme Court and lost only 6. Sterling was everything that Isabella Montgomery was not: 62 years old, silver-haired, with the kind of patrician bearing that suggested centuries of legal pedigree. His courtroom manner was theatrical but effective, combining intellectual arrogance with rhetorical flourishes that had swayed Supreme Court justices for over 2 decades. When Sterling learned that the new Chief Justice would be presiding over the Blackwater case, he was privately delighted. He viewed Isabella as exactly the kind of inexperienced figurehead that he could easily manipulate through a combination of legal complexity and subtle condescension. His strategy was simple: overwhelm her with constitutional minutiae while treating her with the kind of paternalistic respect that would make her feel important while ensuring she deferred to his superior experience. "Gentlemen," Sterling told his team during their case preparation meeting, "we're facing a Chief Justice who looks like she belongs on a magazine cover rather than the Supreme Court bench. Isabella Montgomery may have impressive academic credentials, but academic brilliance doesn't translate to judicial authority. She's never handled anything approaching this level of constitutional complexity." His senior associate, Richard Whitman, nodded with the confidence of someone who had helped Sterling dominate Supreme Court arguments for 15 years. "I've reviewed her appellate decisions. They're technically sound but lack the kind of constitutional vision necessary for Supreme Court leadership. She's clearly more concerned with appearing scholarly than exercising real judicial authority." What Sterling and his team had failed to understand was that Isabella's appointment as Chief Justice hadn't been a political gesture. It had been a calculated decision by a president who recognized that the court needed someone whose intellectual brilliance was matched by an absolutely incorruptible commitment to constitutional principles rather than political considerations. Isabella's judicial philosophy wasn't based on ideology or political calculation. It was grounded in a profound understanding of constitutional text, historical context, and legal precedent that allowed her to see through political arguments to the underlying legal principles that should govern American law. She approached every case with the methodical precision that had earned her the Iron Gavel nickname, a reference not just to her inflexible commitment to legal accuracy, but to her ability to forge judicial consensus through the sheer force of her intellectual arguments. The morning of oral arguments in Blackwater Industries v. EPA began with Sterling's team arriving at the Supreme Court with the confidence of gladiators entering an arena where they had rarely tasted defeat. The media attention was intense. The case would determine whether federal environmental regulations could override state authority and corporate interests, making it one of the most significant constitutional challenges in decades. Isabella entered the Supreme Court chamber wearing traditional judicial robes that somehow managed to emphasize rather than conceal her stunning beauty. To the assembled attorneys, legal observers, and media representatives, she looked impossibly young to be wielding the kind of constitutional authority that came with the Chief Justice position. "Good morning, Chief Justice Montgomery," Sterling said as they met before the arguments began, his tone carrying the kind of paternal condescension he used with young attorneys he considered beneath his notice. "I hope you're prepared for the constitutional complexity we'll be discussing today. Environmental regulation cases can be quite challenging for justices who haven't specialized in administrative law." Isabella looked up at the man who had built his career on Supreme Court dominance, her green eyes showing no trace of the deference he expected to see. "Thank you for your concern, Mr. Sterling. I'm sure your arguments will be illuminating." Her calm response irritated Sterling, who was accustomed to seeing nervous respect from attorneys and judges who understood his reputation. But he attributed her composure to naive confidence that would crumble once he began his sophisticated constitutional arguments. The Supreme Court chamber was packed with legal observers, constitutional scholars, and media representatives who had come to witness what many expected would be a masterclass in Supreme Court advocacy from one of the most feared attorneys in the country. Most expected that the young Chief Justice would be overwhelmed by Sterling's rhetorical brilliance and defer to his constitutional expertise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States, the Marshal announced as the 9 justices entered the chamber with the ceremonial dignity that had marked Supreme Court proceedings for over 2 centuries. Isabella took her position at the center of the bench with movements that were graceful but carried an underlying sense of absolute authority. As Chief Justice, she would control the flow of arguments, determine the scope of questioning, and ultimately guide the court's decision in one of the most important constitutional cases in decades. "We'll hear argument first this morning in Case 23-891, Blackwater Industries v. Environmental Protection Agency," Isabella announced, her voice carrying clearly through the chamber despite her apparent youth. "Mr. Sterling." Sterling rose to address the court with the theatrical confidence that had made him legendary among Supreme Court practitioners. His opening was designed to be both intellectually overwhelming and subtly condescending, establishing his constitutional expertise while treating the Chief Justice as someone who needed basic legal concepts explained to her. "Chief Justice Montgomery, and may it please the court," Sterling began, "this case presents fundamental questions about the scope of federal regulatory authority that go to the heart of our constitutional system. The EPA's regulations represent an unprecedented expansion of federal power that violates basic principles of federalism and exceeds the statutory authority granted by Congress. His argument was masterful in its sophistication, weaving together constitutional text, historical precedent, and policy considerations in ways that demonstrated why he was considered one of the most formidable Supreme Court advocates in the country. But his presentation was also carefully designed to make Isabella feel overwhelmed by constitutional complexity while subtly questioning her competence to handle such sophisticated legal arguments. The founders never intended, Sterling continued, for federal agencies to wield the kind of regulatory authority that the EPA claims in this case. Chief Justice Montgomery, I'm sure you appreciate the delicate balance between federal power and state sovereignty that has defined American constitutional law since the founding. The condescending tone was subtle but unmistakable. Sterling was treating Isabella like a student who needed constitutional principles explained to her rather than the Chief Justice who would ultimately determine the outcome of his case. Isabella's response revealed the first hint that Sterling had seriously miscalculated his opponent. Her questions weren't the confused inquiries of someone overwhelmed by constitutional complexity, they were surgical examinations of legal arguments that demonstrated a level of constitutional expertise that shocked everyone in the courtroom. Mr. Sterling, Isabella said, her green eyes focusing on him with laser-like intensity, you argue that the EPA lacks statutory authority for these regulations. But doesn't the Clean Air Act explicitly grant the agency authority to regulate pollutants that endanger public health and welfare? The question was precisely targeted at the weakest point in Sterling's argument. Isabella had identified the exact statutory language that undermined his entire constitutional theory, and her phrasing suggested that she understood the legal implications better than Sterling had anticipated. Well, Chief Justice, Sterling replied, momentarily thrown off balance by the sophistication of her question, the statute must be interpreted within constitutional constraints that limit federal regulatory power. I understand your constitutional argument, Isabella continued, her voice carrying growing authority, but I'm asking about your statutory interpretation. You claim the EPA exceeded its authority, but the text seems quite clear. Are you arguing that Congress lacked the power to grant this authority, or that the agency exceeded the authority Congress actually granted? Sterling's confidence began to crack as he realized that the beautiful young Chief Justice was not only keeping pace with his constitutional arguments but was systematically exposing the logical gaps in his legal reasoning. Her questions weren't the confused inquiries he had expected, they were the precise interrogations of someone who understood constitutional law better than he did. The oral argument continued with Isabella demonstrating a command of constitutional precedent, statutory interpretation, and legal history that shocked everyone who had assumed her youth and beauty indicated inexperience. Her questions were so precisely targeted and her legal reasoning so sophisticated that Sterling found himself struggling to maintain the intellectual dominance he had expected to establish. Mr. Sterling, Isabella said during one particularly devastating exchange, you cite the Commerce Clause cases from the 1930s, but don't those decisions actually support broader federal regulatory authority rather than the limited interpretation you're advocating? Sterling's response was halting and defensive, revealing that he hadn't anticipated facing this level of constitutional expertise from someone he had dismissed as an inexperienced figurehead. The attorney who had dominated Supreme Court arguments for 2 decades was being systematically outmaneuvered by the Chief Justice he had planned to intimidate. The turning point came when Isabella began questioning Sterling about the historical context of environmental regulation and constitutional interpretation. Her knowledge wasn't just comprehensive, it was profound, demonstrating an understanding of legal philosophy and constitutional theory that suggested years of scholarly research rather than the superficial preparation Sterling had assumed she would bring to the case. Mr. Sterling, Isabella said with quiet authority that commanded absolute attention from everyone in the chamber, your argument seems to rest on a theory of constitutional interpretation that would effectively eliminate federal regulatory authority in areas where states have traditionally been unable to address interstate problems. How do you reconcile that position with the framers' explicit intention to create a federal government capable of solving problems that individual states cannot handle independently? The question was devastating in its implications. Isabella had just exposed the fundamental flaw in Sterling's entire constitutional theory while demonstrating a level of historical and philosophical understanding that shocked the legal observers who had expected to see her overwhelmed by constitutional complexity. Sterling's response was clearly improvised and intellectually inadequate. The man who had built his career on Supreme Court dominance was being systematically destroyed by the Chief Justice he had planned to manipulate through condescension and legal complexity. But Isabella wasn't finished. During the government's argument, she demonstrated that her constitutional expertise wasn't limited to exposing flaws in opposing arguments. She could also identify the strongest possible legal foundations for regulatory authority that the EPA's own attorneys had failed to articulate clearly. General Thompson, Isabella said to the Solicitor General representing the EPA, "Doesn't the government's argument become much stronger if we focus on the interstate nature of environmental problems rather than trying to stretch Commerce Clause precedent?" The founders clearly intended federal authority to address problems that cross state boundaries. Her question revealed that Isabella wasn't just capable of sophisticated constitutional analysis, she was actively helping to strengthen the legal arguments that would support her eventual decision. The Chief Justice was demonstrating the kind of judicial leadership that transforms constitutional law rather than simply applying existing precedent. During the lunch recess, Sterling confronted his senior associate with barely controlled panic. His usual confidence had been replaced by the dawning realization that he had seriously underestimated his opponent. "Who the hell is Isabella Montgomery?" Sterling demanded, his composure cracking under the pressure of watching his constitutional arguments crumble under her questioning. "She's not some inexperienced figurehead. Her legal knowledge is more sophisticated than half the constitutional scholars in this country." Richard Whitman was equally shaken by what they had witnessed. "Harrison, I think we made a terrible mistake. Her questions weren't lucky guesses, they demonstrated the kind of constitutional expertise that comes from years of scholarly research. We completely underestimated her intellectual capabilities." Sterling's panic was justified. In 30 years of Supreme Court practice, he had never faced a jurist whose constitutional knowledge was so comprehensive and whose legal reasoning was so precise. The beautiful young Chief Justice he had planned to overwhelm with complexity was systematically dismantling his arguments while demonstrating intellectual authority that made his own expertise look superficial by comparison. That afternoon, Isabella's questions became even more devastating as she explored the broader implications of Sterling's constitutional theory. Her analysis wasn't just technically accurate, it was philosophically profound, demonstrating an understanding of American constitutional principles that shocked even the experienced justices sitting beside her. "Mr. Sterling," Isabella said during one particularly devastating exchange, "if we accept your interpretation of federal regulatory authority, wouldn't that effectively return us to the constitutional framework that existed under the Articles of Confederation? How do you reconcile that outcome with the framers' explicit rejection of that system?" The question was so precisely targeted and so intellectually devastating that Sterling had no adequate response. Isabella had just demonstrated that his entire constitutional theory would undermine the fundamental structure of American government, and her historical analysis was so accurate that even Sterling's most sophisticated rhetorical skills couldn't provide a satisfactory answer. The oral argument concluded with Sterling's reputation in ruins and his client's case effectively destroyed by the Chief Justice's systematic exposure of every logical flaw in their constitutional arguments. But more importantly for Isabella's long-term authority, she had demonstrated to the entire legal establishment that her appointment as Chief Justice wasn't political favoritism, it was recognition of intellectual brilliance that exceeded anything the Supreme Court had seen in decades. 3 months later, Isabella delivered the majority opinion that would establish her as the most formidable constitutional mind in Supreme Court history. The decision wasn't just a victory for environmental regulation, it was a masterpiece of legal reasoning that redefined the relationship between federal authority and constitutional limits in ways that would influence American law for generations. The question before this court, Isabella wrote in language that combined legal precision with philosophical depth, is not whether federal regulatory authority should be preferred to state sovereignty, but whether the constitutional framework established by the founders provides adequate tools for addressing challenges that transcend state boundaries and require coordinated national responses. Her analysis was so thorough, her reasoning so compelling, and her constitutional interpretation so intellectually unassailable that even the justices who disagreed with her conclusions were forced to acknowledge the brilliance of her legal arguments. The decision established precedents that would guide environmental law for decades while demonstrating the kind of judicial leadership that transforms constitutional interpretation rather than simply applying existing rules. But the most devastating aspect of Isabella's majority opinion was her systematic destruction of every argument that Sterling had presented during oral arguments. Her legal analysis didn't just reject his constitutional theory, it exposed the intellectual inconsistencies and logical fallacies that rendered his arguments not just wrong, but embarrassingly inadequate for Supreme Court consideration. Petitioner's constitutional theory, Isabella wrote with clinical precision that was more devastating than any emotional attack, rests on historical misinterpretations, precedential misreadings, and logical inconsistencies that would require this court to ignore both constitutional text and the framers' explicit intentions regarding federal authority. Sterling's career never recovered from the intellectual humiliation of Isabella's majority opinion. The Supreme Court bar recognized that he had been systematically outmaneuvered by a Chief Justice whose constitutional expertise exceeded his own, and his reputation as a formidable advocate was permanently destroyed by his failure to recognize Isabella's intellectual capabilities. More significantly, Isabella's opinion established her as the intellectual leader of the Supreme Court in ways that transcended traditional judicial authority. Her legal reasoning was so sophisticated and her constitutional analysis so profound that she quickly became the justice to whom other members of the court deferred on complex questions of constitutional interpretation. The beautiful young woman that Sterling had dismissed as an inexperienced figurehead had demonstrated intellectual brilliance that established new standards for Supreme Court jurisprudence while destroying the career of anyone arrogant enough to underestimate her capabilities based on age and appearance. Law schools across the country began teaching Isabella's majority opinion as an example of perfect constitutional reasoning, and her methodology became the standard by which Supreme Court decisions were evaluated. The Iron Gavel nickname that had once referred to her inflexible commitment to legal accuracy now represented her ability to forge constitutional consensus through the sheer force of intellectual arguments that no competent attorney could challenge. What Sterling and his colleagues had failed to understand was that Isabella Montgomery's appointment as Chief Justice wasn't the product of political calculation. It was recognition that the Supreme Court needed someone whose constitutional expertise was matched by an absolute commitment to legal principles that transcended political considerations. The stunning brunette they thought they could manipulate through condescension had reminded everyone that some judicial authority comes not from age or experience, but from intellectual brilliance so profound that it transforms constitutional law while destroying anyone foolish enough to mistake beauty and youth for weakness rather than camouflage for unprecedented legal competence. Harrison Sterling learned too late that assuming inexperience based on appearance wasn't just wrong, it was career suicide when facing someone whose perfect legal mind was disguised by ethereal beauty but revealed through constitutional reasoning that established new standards for Supreme Court excellence. Chief Justice Isabella "Iron Gavel" Montgomery had added another historic victory to a perfect judicial record while permanently altering American constitutional law, and her majority opinion would be remembered as the moment when the most beautiful Chief Justice in Supreme Court history proved that some legal minds are so brilliant that they redefine judicial authority for generations to come.